to welcome all of you to this, the 11th in a series of annual lectures dedicated to Judge Thomas Fairchild, who sits over here at my left, a series that is created by the judge's former law clerks to honor him. As Dean of the Law School, as you might imagine, I frequently am involved with kicking off events and introducing speakers, and certainly nothing gives me greater excitement and pride than when one of those speakers is one of our own faculty colleagues here at the law school. Marc Galanter is presently the John and Rilla Bossard Professor of Law, as well as Professor of South Asian Studies here at the University of Wisconsin-Madison. In addition, he is the director of the law school's Dispute Processing Research Program, one of the leading centers for empirical study of the legal system, and he's chairman of the Institute for Legal Studies. One of the most amazing things about Marc is that he has managed to carve out an international reputation in a variety of quite separate fields. They range from, and I'm sure I'll probably forget some in terms of my introduction, but they include the empirical study of litigation and patterns of disputing and dispute processing, also the organization of the legal profession, and I think probably more a part of his earlier career, the law of India. And that's just some of the formal things. I also know, because Marc and I used to share an assistant, that he is also one of the leading national authorities on lawyer jokes, something that we probably all hear too many of, Marc, but maybe you'll share some with us as well. So it is a great privilege for me to introduce our law school colleague, Marc Galanter, to deliver the Fairchild Lecture. Marc?
Thank you, Ken. Judge Fairchild, friends, colleagues, guests, it's a great honor to be invited to give this 11th Fairchild Lecture. I have to warn you that I'm afraid this one contains more numbers than the first 10 combined. And I can only repay your patience with an observation attributed to George Bernard Shaw, who said that the mark of civilization is the capacity to be deeply moved by a statistic. Well, the statistics I'm going to tell you about are about lawyers growing older. Now, each of us finds this confirmed each morning in the mirror, but lawyers are growing older in another collective sense. The legal profession is launched on a massive demographic transformation that will have dramatic but unknown effects on the way law is practiced and the way legal services are distributed in this society. What I would like to do today is review with you the story of how we got here and to offer some ideas about the future and the options it holds. Because although the aging is inevitable, what we do with the problems and opportunities that it presents is something in which we do enjoy some degrees of freedom, both individually and collectively as well. Well, you're all familiar with the beginning of the story. When starting in the 1960s, more students entered law school each year. The number rose dramatically from 15,000 in 1960. You can see on the figure here, from 15,000 in 1960 to 34,000 by 1970, and leveled off in the low 40,000s after 1980. Well, with these large new cohorts coming in and much smaller cohorts departing, the number of lawyers grew from less than 250,000 in 1960 to 500,000 in 1980 to about 1 million now. And it's been observed that if the present rate of increase persists, the country will soon have more lawyers than people. Well, actually, as Figure 2 will displays, we still have some distance to go. But this is a projection, and unlike you'll see most of the projections here, and I have to say this paper is a collaboration with some demographers here in the Applied Population Laboratory, to whom I'm very grateful for teaching me something about this and working with me on it. This one, just for a lark, we projected up to 2050, but you can see this projects that the legal profession will grow to about 1.25 million lawyers, a little bit more. That is, it's already 4 times the size that it was in 1960, and it'll add yet another 250,000. As you can see, the makeup of the profession is changing in a very interesting way, because apart from the sheer increase in numbers, the profession's changing in important ways. The most visible is the gender composition of the profession. In 1960, 3% of lawyers were women. Today, about a quarter are women, and this will continue to grow, reaching some 40% 20 years from now, and probably a bit more than half by mid-century. Less visibly, this great surge of new entrants transformed the age structure of the profession. It became much younger. It changed from a steep pyramid with slightly more younger lawyers than older lawyers into a very broad-based pyramid with a base consisting of these large new waves of law school graduates and the peak consisting of the smaller, earlier cohorts. Now, appreciate the effects of that dramatic change in age structure. Consider the relative number of lawyers at different ages. And I want to just take lawyers in their 50s to represent senior lawyers who occupy the top positions in various segments of the profession, and lawyers in their 30s to represent young aspirants making their way. And if we could look at Figure 4. And what we can see here is back in 1970, for every 100 lawyers in their 50s, there were 127 lawyers in their 30s. But as the profession expanded, the number of lawyers in their 30s grew very rapidly. Those are the blue lines. And the number of lawyers in their 50s grew very slowly. And so by the time the profession was at its youngest in the mid-1980s, there were almost 3 times as many young lawyers as there were older lawyers, as you could see in that 1985 bars. Then the new people who'd come in the 1960s started to move into the older age categories, and the ratio started to come down. And so what we now have is a situation in which the ratio of younger to older lawyers is falling, and if the number of entrants into law schools remains in the range that it is now, that ratio will continue to drop until by 2020 it will fall to, this is the last columns, it will fall, there'll be almost as many older lawyers as younger lawyers. So the broad-based age pyramid that we've been in for the last quarter century will be transformed into a steep wall with roughly equal numbers of lawyers at every age level. So after a generation in which older lawyers were relatively scarce compared to the abundance of younger lawyers, the profession is entering an era in which older lawyers will be equally plentiful. That is, there's going to be just as many lawyers younger than 50 as there have been for the past generation. But there's suddenly going to be as many, again, lawyers over 50. So this is going to make a return to the age structure of an earlier day when there were similar numbers of lawyers in each age group. But what's happened in the meantime is that the market for legal services and the organization of their delivery has undergone massive change. So I have to take a little detour and talk a little bit about what's known about the market for legal services in the shape of law firms. The consumption of legal services has increased dramatically during this period. Between 1967 and 1993, the legal services industry, that's what the census calls lawyers in private practice, the industry share of the growing gross domestic product rose from about 0.6% to 1.6%. And this is an enormous increase in the size of the legal services pie. And as that pie was increasing, there was a major change in the way it was being sliced up. What we see in Figure 5 is the change in who's buying the legal services. So legal services here are sorted out, the total is sorted out by the different categories of buyers at these 5-year intervals. And as you can see, although individuals end up buying more legal services than they had before, a larger and larger portion of the overall total of legal services is purchased by businesses. So individuals' expenditures goes up about 2.5 times in this 25-year period, and law firms' income from businesses, it goes up about 5.5 times during that period. So more and more of the legal world is devoted to servicing organizations rather than individuals. Now, when the profession's population explosion began, the contours of private practice were very different than they are now. Almost all lawyers were solo practitioners or in what would now be regarded as very small practices. In 1960, there were about 200,000 lawyers in private practice, and almost 2/3 of them were solos. Today, there's 700,000 lawyers in private practice, and about 47%, something like that, are solo practitioners. So the number of solos has actually increased. There are 2.5 times as many now as there were in 1960. But the number of lawyers in firms has grown about 5 times, from about 70,000 to about 370,000 now. And then back in 1960, there were just 38 firms in the United States with 50 or more lawyers. So the large firm sector contained a couple of thousand lawyers. It now contains over 100,000. So that sector of the profession grew about 50 times as large, while solos grew 2.5 times, and all firms grew about 5 times. So a far greater percentage of all private practitioners are involved in hierarchic organizations in which younger lawyers staff the lower reaches and older lawyers the upper echelons. Can we see Figure 3, please? So this gives a sense of the different work settings in which lawyers are working and how the number of lawyers in each of those settings has changed over the past 20 years, and it projects forward over the next 20 years. Now, obviously, the projections are based on various assumptions, and the further out we go, the more shaky they are as predictions. But you can see that solos and large firms, the numbers of lawyers in them have been growing very rapidly. Smaller firms, 11 to 50, have been growing. Everything else is pretty much flat in terms of the number of lawyers involved in them. I want to talk a little bit about the large firms, because they have a distinctive structure. They're divided into partners who own the business and salaried associates, highly qualified law graduates who compete over an extended 5 or 10-year period in a more or less meritocratic tournament in which some are chosen to become partners and typically the others depart. Now, this core of tenured and tenure-track lawyers is surrounded by a small but growing periphery that may include temps, contract lawyers, permanent salaried lawyers, and lawyers in an of-counsel relationship. So these are the sort of adjuncts and emeriti of the law firm world. Firms organized this way around a promotion to partnership tournament contain somewhere between a quarter and a third of all the private practitioners and include most but not all of the most prosperous practitioners and those with organizational clients. So virtually all the firms that service the corporate sector are organized in this way. And these firms contain an inherent growth dynamic. They tend to grow exponentially. And as the market for legal services has expanded, these firms have multiplied and grown. So in 1935, the average size of one of the 250 largest firms was about 138 lawyers. Today, it's just over 300 lawyers. Now, as these firms grew, their old world dissolved, that world of assured tenure, very little lateral movement, enduring retainer relationships with loyal long-term clients. In its place rose a new world of rapid growth, mergers, breakups, overt competition, aggressive marketing, attorney movement from firm to firm, fears of defection, and pervasive insecurity. And so throughout the law business, relations are far more fluid. The mobility of clients is matched by mergers and breakups of firms and by the increased mobility of individual lawyers. Within the firm, the tournament is prolonged. Earlier, the fortunate few who gained partnership in a sizable firm acquired a kind of tenure. Partners could anticipate that as time went on, they would bill fewer hours with the passing years and could expect to stay on at the same firm until a dignified, often gradual and partial retirement beginning in their late 60s. But the expectations surrounding partnership have been drastically reduced in the new competitive environment. Partners are under mounting pressure to maintain a high level of performance that fits the business strategy of the firm. They're expected to bring in business as well as to contribute to firm revenues by billing long hours. And as firms grow and accumulate ever larger cadres of partners, there's increasing pressure on lawyers over 50, apart from rainmakers and a few superstars, to make way for younger partners and eventually to leave. So as with professional athletes, there are now real possibilities of late career downward movement. By the early 1980s, there were reports of partners having the prerogatives or shares reduced or even being de-equitized or de-partnerized, as the legal press described it, or pushed off the iceberg altogether. As one observer summed it up, partnership used to be forever, but it is no longer. So the shape of lawyers' careers is going to change radically because of the presence of a much greater number of older lawyers. But the changes are not going to be the same in the two hemispheres of the practicing bar. Among the solo and small firm practitioners who serve individual and small business clients, there will be ever more lawyers competing for business. The number of lawyers in these practices will continue to increase in the coming decades. We could see that continuing increase in the number of solo practitioners. But the supply of legal services will increase even more rapidly than the number of lawyers, as new technologies for retrieving and generating documents will make lawyers more productive, new business formats will make them more efficient in delivering services, and non-lawyer advocates, banks, trust companies, and paralegals will be competing for important segments of this business. So even though demand for the services of small practices can be expected to continue to rise, this demand will fall short of the expected increases in supply. Lawyers in this sector have been experiencing falling real income for several decades, and the prospect for higher incomes overall in this sector is remote. But typically, lawyers in this sector have been able to remain in practice into their 60s and 70s, but as competition intensifies, many in this sector are going to find themselves underemployed. Now, in the large firm sector, the overall total of business is likely to increase more rapidly if the trends we've seen continue. Could these firms promote to partnerships sufficient numbers of young lawyers and also retain larger numbers of existing partners until the traditional retirement age? Well, as the size of a partnership grows, additional revenue is needed to maintain the income of the partners. So long as the level of partner income depends on the leverage of associates, growth of the partnership peak of the firm pyramid would require a corresponding growth in the associate base. While some individual firms will succeed in finding substantial amounts of new work, the revenues of large firms taken as a whole can only grow as fast as business spending on legal services, even assuming that there's no major diversion of that spending away from law firms to accounting firms. So it's unlikely that many firms could broaden their associate base sufficiently to support a greatly enlarged number of partners. And firms are concerned about what they consider an excess of highly paid older partners and the need to create space for newly promoted partners. And they've responded to that by enacting new retirement policies that provide lower ages for mandatory retirement and for earlier voluntary retirement. So increasingly, large firm practice has become a young person's game. In a comprehensive picture of American law firms in 1995, the American Bar Foundation found that the median age in firms of more than 50 lawyers, the median age of associates was 30, the median age of partners was 43. Only 13% of partners in these firms were 55 or older. So there's an inverse relationship. You can see figure 8. You see here, there's an inverse relationship between the size of firms and the presence of older partners. The blue are partners over 65, and the red are partners between over 55. And as you can see, as firm size increases, there's a steady downward progression of the number of the presence of these older lawyers. The larger the firm, the thinner the presence of older lawyers. So lawyers in large firms are more likely to end their partnerships earlier than their counterparts in smaller firms. So in the end, many lawyers otherwise eligible to be partners will not be because the firms can't accommodate them. In some cases, they won't be promoted, but there's a severe limit on how far firms can restrict promotions to partnership, since they have to keep promoting to maintain the motivation of associates and to position themselves in the hiring market for young lawyers. As Table 6 shows, this is the total number of lawyers in the 250 largest firms, and the blue line is associates, the green line are partners. And you can see that even during the severe downturn of the early 1990s, large firms did not stop promoting young people. They stopped hiring people coming out of law school, and they pushed associates out, but they kept making partners at roughly the same percentage rate each year, even as the number of associates fell. So this, as I say, is a reminder of that imperative to keep promoting that seems to be part of the large firm structure. Now, if firms are constrained in their ability to limit promotion, the pressure to curtail the size of the partnership will fall on those who are already partners. Pressure to leave gracefully, take early retirement, accept of counsel status, or hang on with diminished status and a reduced share. In consequence, the shape of a career in large law firm practice is changing. It's changing from a lifelong trajectory culminating as respected elder to a compressed period of 25 to 30 years of intense and lucrative involvement, followed by a long retirement. That is, unlike the old country doctor or lawyer who died in harness, a career in corporate law is coming to represent, it's beginning to resemble one in investment banking, where careers phase out by their late 40s. But perhaps an even closer analogy is the military, where career officers leave the service in middle age, except for the few slated to move into the highest ranks. And just as military people anticipate and plan for their second careers, so big firm lawyers will soon begin to think about what next. It seems probable then that many of the much larger number of over 50 lawyers that will soon populate the profession, and let me show you those numbers, that's figure 7. Yes. You can see that the great surge of people, of young people that came into and increased the size of the profession in the 1960s and 70s, as they become old, we will have a similar great surge in numbers of, and this is just lawyers over 50 years old out to 2020. And that means somebody who's going to be 50 in 2020 is already a 30-year-old lawyer. So this is pretty, these are pretty firm figures, unless for some reason a lot of these people should decide to leave the profession before. So if we think of this much larger number of people, now many of them are going to be financially secure and good health. A significant portion, as you can see, will be women, and I should say that although we have some basis for anticipating the preferences of male lawyers in navigating the later stages of their careers, there's virtually no information from which to predict the choices of these large cohorts of women lawyers. There are, of course, already a small number of older women lawyers, but a good portion of those who entered law school before the great surge of women in the late 1960s are atypical path breakers and pioneers from whom it would be very risky to generalize to the broader, more varied group of women who followed them to law school after 1970. So, 20 years from now, there's going to be an additional, this shows there's going to be additional 250,000 lawyers over 50. The number of lawyers below 50 will not change very much, if at all. So there's going to be a whole 250,000 additional lawyers over 50. Now this is an immense and rapidly growing pool of human capital, roughly equivalent in size to the legal professions of the entire European Union. And as far as, unless there's some major changes in the organization of professional opportunities, much of this human capital will be underutilized. So surely there will be many ideas about how to employ this wonderful resource, and since one size doesn't fit all, there's certainly ample room for ideas here. I want to use the opportunity of the Fairchild lecture and the example of Judge Fairchild himself to advance one idea for your consideration. Because in spite of the very large number of lawyers practicing in the United States, many persons and interests are underrepresented and underserved by the justice system. As law has become ever more technical, complex, and expensive, the legal system has been increasingly congenial to corporate actors and increasingly inhospitable to individuals. Of course, the poor have very little access to the protections and remedies promised by the law. But even for non-poor individuals, few can afford to enter the legal arena unless they're connected to a corporate actor or have some serious injuries that fit the investment strategies of entrepreneurial lawyers. So many of our interests as citizens and consumers just do not command representation in the private fee-for-services legal market because they're diffuse and unorganized. To offset these imbalances, other vehicles for delivering legal services have developed, notably legal services for the poor and public interest law. But the entire legal services for the poor, public interest law sector is vanishingly small and shrinking, whether we measure it by the number of lawyers involved or the amount expended. This sector occupies less than 1% of the American legal system. So, on the one hand, there are by any measure vast unmet legal needs. On the other hand, there's the prospect of an abundance of experienced but underemployed older lawyers. Can these be joined in a way that would deliver desperately needed legal services and at the same time provide fulfilling work to lawyers? Imagine that among the hundreds of thousands of experienced lawyers in their 50s and 60s, there's some fraction who would, if a path were readily available, choose to proceed to a second career as lawyers for the poor or for the public interest. Let me just call this public service lawyering for short. And I would certainly not claim that an inclination to do this is necessarily typical, but we do know that when people enter law school, many think this is what they want to do. And although the law school experience tends to reduce the commitment to public service practice, something we ought to think about why that is, at the end of law school, there's still far more students inclined to do such work than the job market can absorb. So for many lawyers who've spent their careers in other practice settings, these original impulses have survived or revived. For others, the attraction may be new. But are there lawyers with an inclination to take up this work? Just having lawyers so inclined on the one hand and the needs on the other doesn't necessarily bring about an enlargement of the public services sector. It's something like a dammed river in which a few resolute salmon may scale incredible obstacles to reach their ancestral spawning ground. Similarly, a few determined or lucky aspirants presently find their way from private practice to a rewarding place in public service work. But for most who might like to make this journey, there are no paths to follow through the obstacles that abound. So I propose that we need to think about facilitating this transition, like wildlife managers who build ladders to enable large numbers of salmon to proceed upstream. We need to institutionalize paths for lawyers to make this journey. Now, we certainly can't assume that there's a single format for utilizing older lawyers most effectively. But there's really an array of possible formats. Let me just mention a few. The most obvious is to have older lawyer volunteers augment existing legal services offices. Now, concern has been expressed that the experience of most business lawyers is not in areas relevant to practicing for poor people. It's difficult to believe this disparity couldn't be substantially obviated by training programs, but I think the objection may reflect too narrow a view of the legal needs of public service clients. I recently heard an account of a very innovative program for housing families with foster children and the elderly sort of in a kind of symbiotic relationship by acquiring housing in an abandoned Air Force base. It was very imaginative and actually was brought off. But it was evident from talking to the person who designed it that input by transactional lawyers would have greatly facilitated the project and made it happen much faster and perhaps on a somewhat larger scale. And I think this is not a singular occurrence. There's a study of Chicago lawyers who work with the civil rights and urban poverty organizations found that about 20% of the projects that were brought to them were primarily planning projects in which the lawyers counseled, negotiated, drafted legal documents, and so forth. So an infusion of lawyers with new kinds of expertise in ERISA or banking law, may usefully broaden the repertoire of the legal services sector, turning these into tools to address the problems of poor or unrepresented clients. A second format would be freestanding firms of legal service providers. And let me again give a single, and I found very impressive example. I recently encountered a retired New York corporate lawyer who, after 4 years with Westchester Legal Services, in which he was extremely unhappy with the restrictions under which he felt forced to work, restrictions, I should say, originating in Congress, not in the legal services organization. He has now founded something called Legal Services for Children, which will be staffed entirely by retired law firm partners, he says, and women who have left the profession to raise families and want to come back and use this as a transition back. Legal Services for Children will serve poor children, but will also, because it's trying not to take any government money, will be able to take cases from non-poor clients that are relevant to its concerns. For now, it's funded by gifts and grants, but expects to cover 60% of its budget by fees within 3 years. And there are other formats as well, retired lawyers remaining at their old firms and serving as a pro bono department, or participation in law school clinical programs, but you get the point. There's lots of ways this might be done. Now, I don't want to minimize the cultural as well as the organizational challenges in arranging for such practices. Would prosperous lawyers accustomed to a much higher level of resources and support services, as well as superior physical facilities, find it agreeable to work in the more austere legal services setting? How about, would lifetime legal services attorneys relate to these volunteers who have not shared their sacrifices and frustrations? So there are many obstacles, but I think retired lawyers could bring to the public services sector not only a major increase in manpower and a large repertoire of expertise, new political support, and an infusion of lawyers able to act assertively on behalf of their clients, free of career and command pressures. That's the nice thing about getting old. In terms of personal fulfillment, that is, so I've been talking about the kind of general, the general benefits from this, but I think there are many personal benefits too. There's reason to anticipate a very substantial payoff in personal fulfillment from this kind of shift to public service lawyering. As people age, they experience a deficit of meaning and purpose in their lives, and I think for American professionals particularly, much of their sense of purpose and personal growth is connected with their work. Well, if you look at the press, you'll find a lot of stuff that says lawyers are very unhappy and dissatisfied. You get these images of desolate, despondent lawyers. But the more reliable research suggests that overall lawyers are about as satisfied with their work as other occupational groups. But that research reveals really striking differences in satisfaction between the different sectors of the profession. Public interest work seems to promote the most intense feelings of satisfaction among its practitioners, and private practice, especially in large firms, the least. Curiously, then, those lawyers with the highest incomes and in specialties which enjoy the greatest prestige are on the whole less satisfied with their lives as lawyers. A study of the contemporary Chicago bar finds public interest lawyers the most satisfied, those in large firm practice the least satisfied, with government and corporate lawyers in the middle. There's a far more detailed study of graduates at the University of Michigan Law School, which produces exactly the same pattern. And the striking correspondence of the relative order of these different practice settings in the Michigan and Chicago results suggests that this doesn't just represent the idiosyncrasies of some specific set of lawyers. We don't know what the third study will show, but at least it's very suggestive that there's a great deal of personal, well, is there personal gain here? Might some of these rewarding feelings of meaning and purpose be captured by those who turn to public service work? Now, recall that many private practitioners started out thinking this was what they wanted to do. Do the minority who actually went into public service carry some special predilection to find fulfillment in that work that isn't present in those whose original public service inclinations did not survive the culture of the law school or the contingencies of the job market? Well, we don't know. But there are several considerations that I think commend optimism. First, the fraction of lawyers who make this transition to public service work need not be very large. Remember, I said the whole public service sector is less than 1% of the entire American legal profession. So, if just 1% of lawyers over 50 were to follow the second career option, the supply of lawyers for the poor would be enormously enlarged. Secondly, the timing is fortuitous. In the coming decade, those in commanding positions in firms and in the legal establishment generally, and the bulk of lawyers over 50 will be drawn from cohorts likely to be responsive to the appeal of public interest and public service. The lawyers who are going to be proceeding through their 50s in the coming decade went to law school in the period from the mid-1960s through the late 1970s, a time of ferment, excitement about poverty law and public interest law, and misgivings about corporate practice. If there's any cohort of lawyers among whom the appeal of public service work should be revivable, it is the law graduates of this period. Now, I think in addition to these benefits for the poor, for the lawyers themselves, I think there are some interesting, welcome side effects for the legal profession as a whole. Let me just mention a few. In recent years, as I'm sure you're all aware, public estimation of lawyers' honesty and ethics has fallen. And although the causes of public antagonism toward lawyers are complex and not reducible to a simple reaction to bad behavior by lawyers, one of the grounds on which the public is critical of the profession is its perceived lack of devotion to justice. In a national survey conducted a few years ago, respondents were asked to compare the contemporary lawyers with those of the past. And the researchers said, the public contends that lawyers have suffered the greatest decline in the areas of defending the underdog, providing leadership in the community, and seeking justice. Now, well, one might argue that this image of the profession's past that underlies these judgments is idealized. Nevertheless, this verdict of a public service deficit in present-day lawyers is undeniable. 64% of the respondents thought lawyers had completely or partially lost the trait of a seeker of justice. 55% similarly thought they lost being defenders of the underdog. Now, when these people were then asked, what would improve your opinion of lawyers, the response most frequently chosen, actually by 70% of people, was that lawyers provide free legal services to the needy and to local charities that help the needy. So even though expanding legal services is not, as far as we know, a priority for most Americans, the pro bono delivery of such services elicits strong approval. Again, the prevailing system for according prestige within the profession is largely attuned to the provision of service to large corporate organizations. Studying the Chicago Bar, Hines and Laumann observed, the higher a specialty stands in its reputation for being motivated by altruistic as opposed to profitable considerations, the lower it is likely to be in the prestige order. That is, if it's altruistic, it's low prestige. Now, if that's the existing prestige hierarchy, I think a future in which a significant number of lawyers who are high in the existing prestige hierarchy move from corporate work to public service work, visibly reaffirming public service as a value that's central to professional identity, might help to recast the system of professional prestige and open possibilities for reconstructing the profession's sense of its role. Well, by courtesy of new technologies, the 1.25 million lawyers that will be on the scene in 2020 will be more productive and better informed than their counterparts today. More than 40% of them will be women, more than half will be over 50. Will the definitions of eminence and success remain unchanged? Perhaps the definitions of success that are familiar to us were tied to a particular historical moment, the great expansion of the profession that for a generation shaped a world of many young lawyers with relatively few older lawyers, a world that meshed perfectly with the expanding hierarchies of large firms and that were capable of delivering a satisfying career. But now we're undergoing a second demographic transformation, which ordains that only a declining minority of an older profession can play out that kind of satisfying career, and for a shorter span. So this portends both a change in the forms of practice and corresponding changes in ideas of professional success. Now these are obviously speculative when I talk about these effects, but the demographic change that underlies them is not speculative. It's already in the pipeline. It's going to happen. There are going to be hundreds of thousands of older lawyers who are not there before. And absent some astonishing sudden change in the pattern of demand for legal services or in the structure of law firms, both of which seem unlikely to me, it's possible that it's not only possible, it's probable that many of these lawyers will be at loose ends and many in the large firm sector will be involuntarily retired. So what is problematic is whether some small portion of those lawyers could be enlisted for a second career in public service lawyering. The difficulties are formidable, but it's time to start thinking about the ways of facilitating such enlistment and utilizing this vast pool of talent and experience. Now, this aging of the legal profession is our little piece of a much wider phenomenon, the aging of the baby boom generation. It's also an instance of structural lag in which the institutions of law practice are not articulated to the new population structure produced by demographic shifts, longer life expectancy, and better health. The future remains tantalizingly hidden, but some of its contours are discernible through the mists, enough to enable us to begin planning for the inevitable transition that presents a great opportunity and challenge to our lawyerly ingenuity. Thank you. Yeah, sure.
If there are any questions for Professor Galanter, I think he'd be delighted to answer them.
Or answers. Yeah, yeah. Richard?
As a small firm practitioner, what you're talking about is terrifying.
oh, thanks, is potentially terrifying, inasmuch as there will be this large number of highly prestigious lawyers who will be in competition. The great majority of small law firms overlap to some degree with legal services. We are providing, apart from perhaps more interesting or unusual work, a great deal of our time is spent doing the routine divorce, the simple bankruptcy, the misdemeanor case, what have you. I think there are going to be a lot of people who don't need to collect fees the way we do, who are going to be suddenly left with nothing to do but encroach. What could be done about this?
I'm not sure there's an answer. It is obviously a further factor, it seems to me, in the kind of increased competition that small practices are going to be subjected to. But I do think that in the design of these programs, it's possible to try and focus them on work that presumably is not being done. And it seems to me, at least for the present, there's plenty that's not being done by anybody that would keep lots of people busy for a very long time. Yeah.
What do you think the effect of these demographics would be on the growth of alternative dispute resolution, that is mediation and arbitration and other methods, alternative methods?
Well, I think that may have more to do with the demographics of the judiciary and whether governments are willing to enlarge the size of judiciaries to basically keep up with rising population and rising use of the legal system. It's, you know, I'm not sure there's a direct connection with ADR here. I think ADR will probably, as we know, a lot of ADR is staffed by older lawyers, particularly the judges who retire and go into ADR. And so I think there'll probably be more people who see this as an alternative late career, and so there'll be a lot of people trying to do it, and you know, whether they'll succeed in developing constituencies who are willing to pay for that service, I don't know. Yeah.
The latest buzz in the law profession is a multidisciplinary practice, and it raises the specter of whether lawyers as we know them today will even exist in a generation. Do you have a comment on that?
Well, you can't say that. I mean, the Greeks didn't have lawyers, the ancient Jews didn't have lawyers, so it is possible for societies to get along without them, but I think we're pretty entrenched, and just the inertial drag of path analysis will keep us in business for a very long time. I think it may be that interdisciplinary services come along. And thrive both in the large firm sector and in terms of small practices too. But it's difficult to see that will necessarily reduce the aggregate amount of lawyering that gets done. In some sense, it may also generate new markets. You may get a lot of work done by lawyers who happen to be working in things that aren't called law firms but are in accounting firms or elsewhere. So I really haven't thought this through, and I'm not sure it's possible to think it through at this point as to just what is portended by this lowering of the barriers between the different professional disciplines. Yeah, Judge Fairchild?
In order to magnify the delivery of legal services to the poor, don't we have to think somehow of changing the trend in terms of government money subsidizing?
Well, I mean, clearly that would be highly desirable, but I guess the question is whether there are alternatives, because as we know, government share of this has been dropping for the past 20 years, and is close to the vanishing point now, at least the federal government. And so I think I was very impressed, as I said, by the man who started Children's Legal Services in New York, because the notion is to make this kind of a practice not dependent on government, so that you're neither financially dependent nor subject to the arbitrary restrictions that government likes to impose on people.
Professor, I'm wondering if you have given thought to expanding legal markets for lawyers, not just older lawyers. Mm-hmm. I'm a sole practitioner concentrating in federal employment, and I know, for instance, that very, very few lawyers in this country will ever take a United States Department of Labor workers' compensation case, because the law is set up, it's impossible to get judicial review on the merits, and impossible to collect your fees, whereas in the state, I'm from Illinois, but in almost all the states we have a very active workers' compensation bar. And there are other areas of practice that are markets that could be developed, and I'm wondering if you've given thought to this.
It's I think, a very interesting observation, and I think with more lawyers, and particularly with lots of lawyers who may be financially secure, and there may be some very interesting kind of innovations in terms of what people decide to do with their time and talent. Whether new area, and I'm sure new areas will develop that that people can actually make a living at, but it's hard to know, to look into the crystal ball and see what they'll be beyond HMOs, right?
Well, Mark, thank you very much again for for a wonderful talk. If I could just brag on Mark for a bit, all of us involved with the Wisconsin Law School have known for a long time about his tremendous impact and the range of his scholarship. But there was a recent event, and it certainly fits in with the character of Mark's talk, that provides empirical validation for all that. A professor at Northwestern Law School did a study of the 25 most influential legal scholars, the 50 most influential legal scholars of all time, through looking at citation analysis and other measures of the influence of their work. Oliver Wendell Holmes was first. Judge Fairchild's colleague, former colleague, Chief Judge Posner was number 2, but Mark followed shortly behind on that list. So it was a tremendous tribute to the importance of his work. And Mark, is a token of our gratitude, something I'm sure you've never seen before, the gargoyle statue that reads,
"Thank you,
Professor Marc Galanter, 1999 Fairchild Lecture."
Thank you.
Thank you. Immediately following this event, there will be a reception at the Lubar Commons, room 5000 at the law school. Before we break, what? 7,200, I'm sorry, thank you. Before we break camp for that, I want to acknowledge the presence of 2 or 3 people here. First of all, of course, Judge Fairchild and his wife were delighted that you could join us again this year. Mark holds the John and Rilla Bossert Professor of Law, and we're very glad that Sabina Bossert could come down and join us this evening. Thanks, Sabina, for coming from La Crosse. And finally, one of the great traditions of the Fairchild Lecture is that it is made available to all of the reading public by virtue of publication in the Wisconsin Law Review. And if you look at the back of your programs, you see a list of not just only the, well, I guess it's the inside back cover of the program. There's a list of the former Fairchild lecturers and the citations to their work. And Laura Caters, the editor-in-chief of the Law Review, is here on behalf of the Law Review. I understand, however, that the symbolic transfer of manuscript has already occurred, so I won't put Marc to the pretense of doing it all over again. But Laura, we really appreciate the Law Review's continuing interest in this important lecture. So with all that said, let's go upstairs and have some refreshments, and thanks again to Marc for really a wonderful talk.